You ever find yourself saying, or having to explain to somebody said, what happened? You'd be like, what happened was, that's usually like a long, drawn out explanation of some nonsense that you got yourself involved in that you could have avoided. So we're going to maybe assist you on certain items that could avoid you having to say
what had happened was.
What had happened was.
All right, I'm ready on, I need Miss Moore to start her video. I need Miss Moore to start her video.
I apologize, Your Honor. I didn't know how to do it.
Okay, so you not knowing how to operate the camera, the phone, has absolutely nothing to do with the judge. If you seem to have so much difficulty, that they will request that you physically appear, because if nothing else, you can physically appear. Because the Zoom is an option that's given to you. It's not forced right now. So you do have the option with this judge to come down, because if you can see right here, there are actual people sitting in the gallery waiting to be seen or to testify or whatever they have to go on.
That's
so
true. Yeah.
you do have the option. So if the phone is the convenience. So you do need to know how to make sure it works. Make sure your Wi-Fi is on.
Yep.
Make sure your data, whatever you have to do to get it going, or you got to borrow somebody else's phone. You have this court data, whatever. They will tell you. They even have a Zoom room in the courthouse.
Yep.
From what I'm been told, because so to say you don't know how to do it, I'm quite sure you can find somebody that knows how to do it.
Well, part of the thing that it says clearly that ignorance is no excuse for the law, for not knowing the law. So they don't take the fact that your ignorance, you don't know how to operate it, that's not acceptable. That still can be considered contempt of court. Remember, this is post-COVID, and this has changed the whole game. And this is now convenient, and people still can't get it together. It's amazing. You can not have music playing in the background. That's just madness right there. That's crazy.
Like, are you on hold for something else? You cannot have these things going on. Like, you cannot have something else going on. You cannot have, like, you can't say I'm gonna call my phone company and be on hold while I'm waiting. You cannot do it, because you can be called at any time.
I'm just trying to pay a bill.
You just can't. You can't do these things, because whether you realize it or not, they're all seen as being in contempt of court. If you're sitting in the gallery, if you're sitting there and the judge is talking to you, you can't be looking at your phone. You can't do anything. The judge, and this judge here, she's very, very, very I don't want to say lenient, because she's very merciful. She's very fair. From the cases that we're gonna go and show you, she does work with you, but she can't work with nothing. You have to give something, because at the end of the day, she's here to enforce and to show you the law and explain it to you, what you've done wrong and the consequences of what you are. And you're there to explain why, what had happened, what caused this, reason, what happened, or whatever. And from there, she can advise you on what your suggestions are. Now, depending on the case, and depending on the crime, and depending on whether it's a violation or whether it's an actual, what's considered a crime, then you would have, the dealings. So then now, this is when it comes into play. But I'm going to say this, whether you realize or not, your behavior in court tells a lot about how the judge can deal with you, because you throwing yourself on the floor and throwing a tantrum and everything like that. The judge will say, oh, lock them up, because nobody wants to be bothered with this, because you just showed that you're not willing to be worked with.
Right. Not knowing is one thing, and straight disrespectful is another thing. Unfortunately, this is what had happened on it right here.
Ma'am, yes, you did know how to start your video. let's just move on. Let's move on. Just don't do that.
You know, like, not to be funny, you make yourself, so you know, then it's like, whether you realize it or not, you putting yourself, like, if she lied about it. I'm not saying she did lie about it because I don't know her circumstance, but it's like
gives the appearance of being blatantly disrespectful.
So you got to really measure yourself when you know, like, she's dressed appropriately. She has a blouse. She has a jacket on. You know, she's presentable and everything. She has a background blurred, so you don't really know which is fine, because, you know, she can be sitting anywhere. You know, she could be, you know, she could be at work. You know, who knows where she's at?
Or the line of the bank.
She could be at the line of the bank. Who knows where she's at? But you know, she has it blurred, so you can't really tell where she's at, which is also respectful too, because you know, you could be in some places that, and then also, you know, you have some places that do not really want you to be recorded, but you know, you just have to be there because maybe that's where they have Wi-Fi. So you may be at a coffee shop or whatever, but you don't want to include them in what's going on.
This is case number 214548501, the People versus Regina Octavia Moore. Defendant is charged with assault or assault and battery, and today is the date set by Judge Baltimore for a probation violation hearing.
I don't know why the person is getting up from the gallery over there on the side, but it looks contemptuous because you don't see no one but her, and she's just standing up in the middle of the judge talking, and you cannot do things like that. There's a certain amount of code of conduct and decorum for the courtroom.
She could have to use the bathroom. You know, I mean, things happen. We're human beings, and we have physical reactions to things. She could be not feeling well or whatever. But, you know, usually what you try to do is you try to make sure, especially if you're going to physically be in the court, you use the bathroom, you do everything you need to do so you can you basically have to just sit there and wait.
Yeah, and there's a court officer still there physically at the court. You can get his attention. You're not in contempt of court. Go ahead.
What's going on? And you can say, oh, I need to use the bathroom. And they'll say, okay. Because especially if you are involved in this actual case.
And you're on camera.
You cannot leave until you're dismissed. Sure. Because your testimony can now be invalidated, which means that they'll say, well, she's not here. You could have been there for 5 hours. And the 3 minutes you need to be there, you left. They'll say, okay, well, now they may wait for you, but they may not.
Ms. Ritter, your appearance, please.
Now, this is the complaining witness right here. She's coming to the podium, but she was not called to the podium. So that can be seen as in contempt also. So you're not supposed to come up until they call you. So even though they said your name or whatever, they'll say is Jane Doe, is John Doe, is, you know, Baby Doe, is this person here? And then you'll say, I'm here, Your Honor. And then they'll say, okay. And then they'll tell you, well, just stay right there, or whatever. And then at that point, you can say, Your Honor, I really do need to use the bathroom. I've been waiting for some time or whatever. And then they may say, okay, well, we'll call a recess or whatever, because the judge has seen that you've been sitting there patiently waiting or whatever. You know, but once again.
Or you'll get checked and say, you should have did that before court started. Yeah, you can't go to the bathroom now. That's on you. You got to hold yourself.
So, you know, it might, you know, but this is when you might say that if you have this issue.
For the record, Your Honor, Christina Ritter on behalf of the people, the complaining witness.
What's going on in the courtroom right now?
Complaining witness,
this is an easy way to get found guilty. Even if you're innocent, you're looking really bad in the eyes of the court. This just looks like blatant disrespect, because she is sitting there the whole time muted. You could have took care of your business and muted whatever you got in the background. They don't want to hear nothing. This is the problem, unfortunately, with now going remote and having the option of Zoom. It's great, but people get simple and they don't stop and actually just think and about the fact that had you been in court, there'd have been no music in the background or no TV in the background.
Yeah, there's no TV in court. There's no Facebook in court. No Instagram, Snapchat, TikTok. There's YouTube because they're recording. But you cannot be on your phone. Like, that's why if you go, they'll tell you to bring something to read, something quiet for you to do or whatever, so that you can sit there and kind of stay alert or whatever. You know, I've seen people even sleeping in the back, but I don't know. I don't know how that case turns out. So.
Podium.
Okay. Ms. Ritter.
Thank you, Your Honor. The complaining witness is in person in the courtroom. Ms. Robinson, speaking to the podium and state your full name, please.
Jackie Robinson.
All right. Ms. Moore, state your name. Unmute.
How do you say Regina Octavia Moore?
So see, if we would have just allowed things to proceed, the person that's here to represent this person, this lady, Miss Regina Moore, is not even here to defend her. So all she has to do is hang back, and she has to wait, because the person who and the judge is saying the person who is here to represent her is not available at this moment, and I'm gonna postpone her case until the afternoon when the person is here to speak for her. So, you know, once again, her not knowing how to do it or whatever, but she did have to show up. And she could just say, you know, I'm here, Your Honor, and that's it. Just hang back.
Ms. Moore, what's all that noise in your background?
Oh, it was the TV. I was in the breakout room. I'm sorry.
All right. Today is a day set for a bond violation. Strike that. I keep saying bond. Probation violation hearing that was set by Judge Baltimore while I was off. And unfortunately, it was not properly set, and the people were not even aware of the situation. Miss Stevenson brought to the court's attention that Miss Coulthurst was the attorney of record. Miss Hauser, I need everyone to be stationary, seated.
I have kids here at home, so.
Okay, well, take care of your kids and come back to court when you finish taking care of your kids. You have a great day and you stay safe.
I'm not saying.
Her off the line. You see, just that fast, she booted the person off the line. Now, here's the other thing. I don't know if you noticed, but she had her arms crossed. The camera was kind of facing up or whatever. It wasn't kind of like directly on her face. So even though she had children in the thing, she could have been off camera while she was waiting and just been, you know, she could have been off camera where you can't be seen, because you can make your camera not be seen. You can you can take yourself off of camera, and she have herself muted and go and check on the kids and see or whatever, and try to put herself in a room where they can do something, you know, put them.
Yeah, she could have muted her video.
She could.
Her name would still be up.
It would still say that she's in attendance, which means you're still there. She's still complying, but now she's dealing with the kids or whatever, maybe getting them something to eat or whatever she's doing. And the judge would not have said anything. The judge would not have known. But you can't sit here and say, I have kids, because they don't. And you know, not to be funny, the judge doesn't have to care that you have children.
Right. Plus, she sounded very disrespectful.
And then you kind of screamed at the judge. You're not realizing you kind of screaming at the judge. And once again, no one's saying you're not frustrated. You're not saying you're not upset, scared, or whatever you're feeling, nervous. Nobody's saying that you're not entitled, that you don't have these feelings, but you kind of have to control these feelings when you're in court, because once again, Judge Bryant is very, 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 but she does demand her respect, and she does. She's supposed to have her respect at the judge, because whether you realize it or not, she's here to interpret the law and to make sure that there's a fair ruling, that they don't just say, that's it, you're going to jail. So she's trying to see a way, once again, like I said at the beginning, to help, to assist, to see if there's some program or something that she can get you, because since you have these children and you do need to take care of them because you're home taking care of them, to see if she can continue to have you be in the same place of having, or maybe even assist you, because she might even say, well, why is it that you're home? You're not working or whatever. You may have a conversation. You know, this may turn out to be a really good opportunity for you, whether you realize it or not, because she may know somebody that know, you know, like they have people in place. Like some of the other things, these people, they do have services. You can ask them for certain services.
Plus, on top of that, also, she also tells you very clearly that she has humble beginnings. She's from the West. She's from a rough area in Detroit, so she's not without understanding of your circumstances. So you can't say that.
That Ms. Coulthurst was the attorney that represented Ms. Moore previously. The court did reach out to the Michigan Indigent Defense Council and asked for Ms. Coulthurst to be appointed to represent Ms. Moore during her probation. And I believe that request was granted. Ms. Coulthurst has indicated that she's unavailable this morning, but is able to log into Zoom this afternoon. So I believe I'm going to just have everyone log into Zoom this afternoon and then set the matter, if necessary, for a hearing.
So see, if we would have just allowed things to proceed, the person that's here to represent this person, this lady, Miss Regina Moore, is not even here to defend her. So all she has to do is hang back, and she has to wait, because the person who and the judge is saying the person who is here to represent her is not available at this moment, and I'm gonna postpone her case until the afternoon when the person is here to speak for her. So, once again, her not knowing how to do it or whatever, but she did have to show up. And she could just say, I'm here, Yana, and that's it. Just hang back.
After the people have had an opportunity to review the evidence. Ms. Ritter?
Judge, thank you. So, Your Honor, the court is correct. The people have not had an opportunity to review the evidence relating to this hearing. I did have an opportunity to speak with Ms. Robinson during a brief break from the court. Ms. Robinson being, I guess, agitated with how the people wanted to proceed as far as holding this probation violation hearing and giving the people an opportunity to give a sound argument and decision in making with this process. She wasn't satisfied with what the people were trying to tell her. So just so the court is clear, and just so Ms. Robinson is clear, it is up to the people. From my understanding, it's up to the people as to how they're going to proceed after viewing the evidence, whether they're going to proceed or not to a probation hearing. And from my understanding, Ms. Robinson has been in contact with Ms. Lurst. So Ms. Robinson is, I guess, has confidence in the probation as to handling this hearing opposed to the people.
Ms. Lurst is not an attorney today. She wasn't one yesterday, and she won't be one tomorrow. I could care less about how Ms. Lurst wants to proceed.
So, right now, we have a breach of ethics.
So now
we have the probation officer has no business talking to the complaining witness. It's not her. She's supposed to be in touch. When you file a case, you sign an affidavit. You have to go to the police. They get involved and they can arrest. Or you go down to the court and speak to the district attorney and how to process it. So right now we have a breach of ethics because the probation officer is telling her how this is supposed to be proceeding.
And the probation officer also has evidence against their own client. So that's kind of a conflict of interest also. So she's sitting there saying the video or whatever, like nobody even knows what this video is. Nobody's seen this video except this probation officer who's not physically here in attendance for the court, or even on the Zoom camera to sit there and say, well, this is it. And if you hear the judge says very clearly, the probation officer could have a law degree, but they're not practicing and they're not the lawyer of record at the time or whatever. So,
and this is a breach of ethics.
This is a breach of ethics, and technically could get the whole case thrown out. Get the whole case thrown out based on that. And even if this person like assaulted and beat this person within an inch of their life, they could now have the whole case thrown out.
And the problem also, she did not talk. She hasn't spoken about any of this information to the district attorney. She's not even talking.
She's supposed to tell the district attorney. She should have told the district attorney, well, did you know or whatever? Like, did you know that I sent the video or whatever of what happened to the probation officer? And they'll say, no or yes or whatever they did, and then they have to fill out like basically a form to receive the information, to review it, to see if it's considered, because it has to be what's called logged into evidence. Yeah. You know, this is based on my my Law and Order TV degree of having watched almost every episode of Law and Order.
And based on the actual law enforcement experience of having done this stuff, I'm here to tell you that that's actually true. It's called a chain of evidence. And on top of that, also, this is also a straight violation. First of all, it seems to me like she has a vendetta against the defendant because she's evidence to a parole officer. Only time you do stuff like that is to get that person in trouble with the parole officer.
And the fact that this person did whatever research, because I'm going to call your parole officer. Like, how do you know who her parole officer is? How do you know who this person's parole officer is? Because
you can actually look it up.
I mean, you can look it up, but the diligence for you to look it up and find out who it is, the same way you did that, you could have gave the video to the DA.
That's extra, yeah.
Yes, maybe this person thought by just giving the evidence directly to the this video directly to the parole officer, they could get them violated immediately. But it seems like this parole officer is willing to work with this person as well, you know, because they could have just violated it, but they like, no, let's let it go through the machine of the court.
So number one, as I indicated in the beginning, the matter was set inappropriately on the court's docket. It should have never been set on the court's docket without the prosecutor having the opportunity to review the evidence. I'm almost, okay, what word am I going to use? Okay, I don't know what Ms. Ritter means when she says that what's your witness's name?
Ms. Robinson.
That Ms. Robinson was irritated with how she want to proceed, but on every day that we live and breathe and court operates, it is the prosecutor's case.
So what happened here is that the probation officer, parole officer, was gassing up the complaining witness because she had, again, she's not in charge of the prosecution. That's the prosecutor's job. And she's complaining about the way that the case is proceeding, which means she's in constant contact with this guy, which is out of order completely.
And also, she's on probation. Probation means that the judges determine that they're going to give you a probationary period, which is a period of time. It could be a month, 3 months, a year, whatever, to determine to make sure that you are complying with what the judge asked of you before you get sentenced. It's an alternative to going to jail. Parole is after you've already served a sentence and they take whatever time is left, or they add time and they say, for this amount of time, you have to comply with what we asked you for in order to be in compliance with that.
And had this person been on parole, she'd have been violated already, because it's obvious that this one came and throwing dirt at her. She's throwing dirt in the game.
So she might not, the person who's trying to bring the charges might not even know the difference. She just might think, I'm going to get you in trouble.
It is the people's case. And what we won't do, what I won't do, is have anybody dictate to me how to run my courtroom, except the Supreme Court and the legislature. Court rules and case law. That's what run my courtroom. Court rules and case law. Okay, so, and that I'm a little, I don't know. Okay, perhaps there was some type of misunderstanding as to who Ms. Lurst is. Ms. Lurst is a probation officer who shouldn't even be talking to the complaining witness.
Those are words you do not want to hear come out the judge's mouth, because that does not look good for you when she's talking about the fact that no one dictates to her how the court is run, which is absolutely correct. No one's supposed to be dictating to her. She's the head of the courtroom. She is the final word in this courtroom.
Until it goes to the Supreme Court or the legislature. Like she said, unless the law is changed, in which case the law is being changed, and then you could say, the lawyer would say, well, you know, judge, according to statute, blah, blah, XYZ, da, 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 as of this date, this is what's being now enforced. She has to stay, and then she will have to adjust accordingly. Like she said, her courtroom, her rules.
Yep. Only a higher court can overturn her case or her decisions. That's it.
Let me be clear. Let me be clear. Ms. Lurst is a probation officer who should be talking to the probationer. She is overseeing the probationer. She has no business. None. Let me make the record clear. She has no business communicating on this level with the complaining witness. Her responsibility and obligation is to the probationer. The only thing Ms. Lurst is supposed to do.
See, even with this, the judge is still saying maybe the victim was misinformed as to who she should speak to.
Exactly.
Still trying to give, trying to give an even playing field.
Is make the court aware of an allegation. She should not meet with the complaining witness. She should not have received a video from the complaining witness. She should have brought it to the court's attention. The video should have been sent to the prosecutor. And then the court would make a determination as to whether or not a probation violation hearing was necessary. So I don't know what you said to Ms. Ritter on the telephone. I don't know. But Ms. Ritter is the lawyer. She's the attorney. Ms. Lurst is the probation officer. Probation officer.
The reason why the judge is going in so hard, because all these people who are affiliated with the court are considered officers of the court, and they have to know their place and to stay in their lane and know the code of conduct. And this is out of order. And she just pushed the judge to her breaking point with just a simple little stupid mistake. I see that moving right there. The complaining witness is about to get herself in trouble because she's going to try to justify herself. Oh.
You can't win arguing with the judge. So the two lawyers argue with each other. So the two lawyers or the two attorneys, they argue the case before the judge, and the judge will stop them, or that's what the overrule. Like if anybody's ever seen at least one episode of Law and Order or any court case or anything, the judge stands there and they stand there. The judge is supposed to be an unbiased individual to interpret and make sure the law is being followed for both parties. So what happens is the judge will sit there and say, what happened? The judge will sit there and say, okay, well, this, and then the one person will say, they might interrupt, and the judge will say, okay, that's overruled, or they'll say no, they'll say, oh, I want that stricken for the record, or they'll say a whole host of different things. But the prosecutor and the defense are the two people that stand up and say, this is what happened. And the prosecutor will say, this is what I say happened. And the defense will say, well, the person that I'm defending says that this is why this happened.
They're the only two that's supposed to say what had happened was.
Exactly. They're the two that's supposed to say, and then the judge will say, what? No. Say that again, or whatever they're going to say. The judge is the one that is supposed to unbiasedly interpret both interpretations.
For Ms. Moore, Ms. Lurst is the probation officer for Ms. Moore. Ms. Lurst is the probation officer for Ms. Moore. Okay. Having said that, we are going to log in for this case at 1:30. The people are going to get a copy of the video from Ms. Lurst, who apparently is the only person who can see the video. That's inappropriate. It's inappropriate on every level. It's inappropriate. It's inappropriate for the video to be on her personal device. It's inappropriate. It's inappropriate for the prosecutor to not be able to view the video. It's inappropriate. It's inappropriate for the defense attorney to not be able to view the video. It's inappropriate. It's inappropriate. It's not appropriate.
So is it inappropriate though? Now, I would like you to count how many times the judge says inappropriate. So then now, the judge said, if I'm not mistaken, inappropriate several times, more than a certain amount. Please put in the comments how many times you think you heard the word inappropriate.
Yeah.
And let us know if you think it wasn't appropriate.
Okay, so we're going to log in this afternoon. If she chooses, I suppose, the witness will send the video to the prosecutor, which is what Ms. Lurst should have done. Upon receipt of the video, she should have forwarded that video to the appropriate people. Okay. The only thing, okay, I think we all know that I feel like it was inappropriate. Okay.
You know,
the judge is very polite, but the judge is very pissed off about this issue.
And she keeps calling into the fact that the probation officer has this video and no one else does, as it's some closely guarded secret that she needs to hold on to, that no one else can know until, you know, she's gonna, I guess.
I love it, she.
You know, well, I'm sorry, he or they, until this person comes up with this video and says, I've got it, right. The case cracker.
Yeah, and they're not even in court.
They're not even in court. Because it's not as if they have it on their phone and they can't pull it up or they can't send it or whatever. Because
I hear you and I got it for you. No, they're not even there. Jeez.
Okay. So, Ms. Ritter, if you are able to view the video by this afternoon to determine and let the court know if, in fact, we do need a probation violation hearing, or then we will proceed in that manner. If you're not able to view the video by this afternoon, then I suppose I'm not going to set a bond violation hearing unless I know, I keep saying bond, and I'm sorry, a probation violation hearing unless there's let me see what the standard is for the probation violation. It's not probable cause. It's what's the one down below that?
Clear and convincing evidence.
Mm-hmm. Say that again, Ms. Stevenson. I'm sorry.
Of the evidence.
Oh, preponderance. That's what yes. Preponderance of the evidence that there's a need for a bond violation hearing. Ms. Ritter, were you even able to speak with the witness regarding what the allegation is?
I was there, so I was able to get an understanding of what the allegations are, and it is no contact, indirectly and directly.
Okay. All right, well, we will be back at 1:30 on Zoom. Ms. Coulthurst has been appointed to represent Ms. Moore. The witness does not have to come in person. There will not be a hearing today. However, if she wants to come in person, she can. But there will not be a hearing today, and we're going to pick a date for the hearing if that's necessary. So I need Ms. Coulthurst because I need her calendar. I need to know her schedule. Okay. Anything further?
Nothing further for the record, Judge. Just that I will contact Ms. Robinson after the docket is complete to see if there's a way that I can get that video to review it before the 1:30 adjournment.
There has to be a way. Ms. Lurst has it. So there absolutely has to be a way. Ms. Lurst has the video. Ms. Lurst, the probation officer, who can't share the video.
And if the witness gave the video to the probation officer, why didn't the witness say, I have the video, it's on my phone or whatever? Because what happened once she gave her the video? Did it disappear from her phone or her whatever source? And the judge is not trying to be nasty, but I don't even think she want to see this lady come back into the courtroom, the witness, because she's like, and she don't have to come back.
For some reason with anybody else. So she has it. So there has to be a way. All right. Anything? What's going on? Why is the officer talking to the witness?
Your Honor, I'm telling her to take her arms down and she's refusing to do so. That's why I was talking.
Because it's time to go. I've been trying to...
Who are you talking to? How are you talking to the judge? It's time to go. I'm sorry, the lady with the stick at the top of the desk is the one that says when it's time to go. You know, you might want to go, but you can't go till the person with the robe and the stick says it's time to go.
But she's not about to say she wants to go. She wants to do something really stupid. Let's listen to see she's gonna say.
Who you talking to? Who you talking to? Who are you talking to? Who you talking to? Who you talking to? Who you talking to? Who are you talking to?
Her and her daughter every day.
You're gonna take her in the back.
Right.
She's gonna stop.
You go, I mean, because
you're gonna stop. You're gonna stop. You're going to stop. You.
Another misinformed person who thinks they're gonna overtalk the judge. It's not gonna turn out well. Let's see this road. How far down the rabbit hole we're gonna go with this one.
So I want to know who's she talking to. Who's she talking to? Who is she talking to?
I think Judge Bryant's about to sit down, and I think Motown Lanice is about to make an appearance because look like it's about to be showtime out here.
You are going to stop. You're going to stop. Ma'am, you're going to stop. Stop it. Stop it. No, stop it. Stop it.
I don't think she's even talking to this lady anymore. I think she's telling herself to the person that she could be. That one that, you know how we saw all over where the guy jumped across on the judge? Yeah. This might be a reversal where the judge jumps across the bench. I think she's telling herself.
I think Judge Lanice just grabbed Motown Lanice and said,
Stop it. Stop it. Stop it.
Ma'am, stop it. That is completely and absolutely unnecessary.
And it's inappropriate.
Why is that? Every day her and her daughter harass me. They're doing things. What y'all waiting for them to kill me? Every day.
Let me tell you what I'm getting ready to do. I'm getting ready to get in my car.
She about to come down here.
I'm sorry, those are words you did not hear a black woman say out of her mouth because it doesn't end well at all.
Because she got her robe on, but that don't mean she might have her house shoes on. She might have a little stool cooking or whatever. She said she got to come down there, which means she might not be there. So she got to come down there. She got to stop what she's doing to come down there. It is going to be ugly.
Somebody about to get it. She's about to get a judicial ass whipping.
And I'm getting ready to come down to the court. You're gonna put we're not having no hearing, and it ain't gonna turn out for you. I'm getting ready to appoint. I'm getting ready to appoint you counsel, ma'am.
I'm gonna have to turn this crock pot off and put my shoes on and get my pocketbook and come down there.
And the witness is not backing down. She just made a crazy face, like, who the hell you think you're talking to? Which is not gonna end up well for her.
Judge Lanice is about to get her purse and come on down there.
And there's no hearing. She was very clear. There's no hearing. It means I'm coming for you. I know I'm coming for somebody, so I know what that means. If she says she's coming down there with what
so
she going to do.
her counsel means she gonna wind up with her own lawyer, her own personal case.
Her own case.
Getting ready to appoint you counsel. That's what's getting ready to happen. So you think it's good for me to come down to my car? You think that's good for you? Let me be clear.
Maybe somebody will hear me.
It's not clear. It's not clear. Let me tell you this. You're going to hear me. You're going to hear me. You're rude. You're being disrespectful. You're being disrespectful to this process. You keep.
This lady is still talking reckless in spite of the fact the judge said what she said. She's not listening.
Maybe somebody will hear me.
Maybe somebody hear me. Yeah, the judge heard you. That's why she's getting her keys.
Rolling your eyes at me. You keep tooting up your mouth at me. You keep over talking me. I have asked you to stop. I have raised my voice. I have lowered my voice. You continue to be rude. You continue to not let the process go. You continue. And then while you're continuing to behave in this manner, you want the prosecutor to present evidence to me that you're the one being harassed. Now, what I'm saying to you is that you are going to stop. If you continue, I am going to hold you in contempt of court. And that is not a good thing. If I get in my car to drive downtown, there is a 90% chance.
It's proof everywhere black folks live, we live uptown. Not just in New York. No matter what city we live in, we live uptown.
If I get into my car and drive downtown to address you, there is a 90% chance that you are going to go to jail today. So you're going to stop being rude to me. You're going to stop. You're going to stop, because what you must think is that this is a free-for-all and you can talk when you want to talk. Well, ma'am, that's not how court works, and you're going to stop. You're going to stop. There's not going to be a day. There is not going to be a day when I'm not going to be in charge of this courtroom. There's not going to be a day, ma'am. So I need you to stop. Now, I am trying to address your issue. You are making it 1,000 times difficult for me to address your issue. What you're going to know is that this is a misdemeanor. This is a misdemeanor. So you said, what we going to do?
So a misdemeanor is a crime that is punishable up until 1 year in jail. A felony offense is anything a year or more. The difference between the two is the fact that felonies usually are violent in their nature, by nature, or to level, or what, no matter what it is. There's robbery, felony, the weapon involved, burglary, weapon involved, assault, felony assault. You got hurt bad. You know, violation, it just means it's not even a crime. Crimes are only misdemeanors or felonies.
And so also, if I'm not mistaken, this is about her. They have some sort of order that they're not supposed to be around each other, and she happened to run into her. So the same thing, like if you were going to, you have a order of protection from somebody, and unfortunately you two live in the same neighborhood or whatever, and you go to the same grocery store. I mean, unless you have it in court that you're not supposed to be at the grocery store between this time and this time, or whatever, you happen to be in the same McDonald's, wherever.
Right, or they both ride the same bus.
Oh yeah, ride on the same bus.
And they gotta go at that time.
And you gotta go at that time. You know, in which case it's an accident. So that, you know, is it considered a violation of the agreement? Yes, it is considered a violation of the agreement. But at the end of the day, the person can say, well, what happened was I missed the bus I was supposed to get on, and I wound up getting on this bus, and this person happened to be on the bus. But if you appear, say for example, if you appear at the bus stop and this person is already there, then it's best for you to leave to avoid these kind of situations.
We're going to wait for her to kill you. This is a misdemeanor. Misdemeanor. If you have an issue that you think is bigger than this, then you need to go talk to Kim Worthy. Look like you're in the wrong place. You need to go across the street and yell at Kim Worthy, but you're not going to keep yelling at me, because when you yell at me, you're going to go to jail. And then you can yell at them from over there in the jail. But what you're not going to do is disrespect and yell at me. That's not what you're going to do. Every day I come to work and put on this black robe I'm in charge of this courtroom every day. Every day. And you're not going to disrespect me. Now, this morning, you have disrespected me. This morning, you have disrespected this process. This morning, you have been very disrespectful. This morning, you have yelled at me and talked over me. I don't know where your emotions lie. And I don't know what Mr. Lurst told you. But let me make something clear to you today. Judge Elanice Bryant is in charge of this courtroom. Judge Elanice Bryant is going to give justice to whoever is in need of justice, but she's not going to prison. It's a misdemeanor. It's a misdemeanor. So you need to talk to somebody else who's able to give you the relief that you need, but you're going to stop yelling at me. You're going to stop yelling at me. And know this, the officer is in charge of that courtroom. The next time he gives you a directive and you don't follow it, I'm going to hold you in contempt of court. You're not going to argue with my officer. He is there for the security of that courtroom. He is there to make sure that courtroom decorum is followed. That is why he is there. The fact that you would argue with him speaks volumes about you, number one, and number two, it's disrespectful to this court process and to these proceedings. Now, I understand emotions get high. I understand that. I understand that you're the one living your situation, but you're not going to come here and yell at me. You're not going to come here and disrespect me because I've done nothing to you. Nothing. I don't even know you. I've never met you.
And this is a shame. This is one of the most compassionate, merciful judges you have on the bench. She listens. She understands. She takes in consideration your circumstances or what's going on with you. She doesn't just slam the gavel down on you and say the hell with you. She actually takes time and she's compassionate. And you're pushing this judge, one of the most reasonable judges on the panel, you're pushing her to her limit. That is not correct. That's out of order.
I've done nothing to you. Neither has my court officer. We are here to do a job. We are here to conduct business. We are here to listen to all sides, not just yours. And you yelling at me, trying to tell me your side is going to accomplish zero, nothing. Absolutely and positively nothing. If you need a PPO, go get one. We don't give them out in this courtroom. If you need some larger charges, go talk to the prosecutor's office. We don't do that here. But what we do here is demand courtroom decorum. What we do here are handle the misdemeanor cases that appear before this court. The cases that are punishable by 93 days in the Wayne County Jail, maximum. This case, maximum. So don't ever do that again, ma'am. Don't ever do that again. Don't ever do that again. Don't ever do that again. All right. As I said before, the witness started yelling at me and over talking me and all of that. We're going to come back at 1:30. And Ms. Moore's attorney will be present. Ms. Ritter will do what she always does and determine if whatever the evidence is, if she is going to proceed with the probation violation request. And then Ms. Lurst, who's not an attorney and who's not going to be presenting any evidence to this court, is going to, as much as we can, try to forward the video to the parties, or Ms. Ritter, if she's going to give you the video, she can give it to you. I don't know. I don't know. I don't know. Okay. Is there anything further for the court?
Not from the people, Judge. Thank you.
All right, Ms. Moore, Ms. Colthurst has been appointed to handle the probation matters, and so log back in at 1:30.
Yes, Your Honor.
All right, then we're all set, and I'll see everyone this afternoon.
Thank you, Your Honor.
Thank you, Your Honor.
Respectful to me. Everybody's going to be respectful to me, or it's not going to be a good day. I'm ready on Hauser, who is also going to be respectful to me. Okay, now, Ms. Hauser wasn't in the courtroom when I just gave this long speech.
Don't get seen by too many new judges.
No, exactly. And so the whole thing is, now Ms. Hauser is back, but had she not been disrespectful, she wouldn't have got herself on the hit list. This is the way you get yourself on the hit list, even not being in court, because of stupid things you do in court. And now she's on the hit list coming in to the court. Let's see how this plays itself out.
About being respectful to me, but this 2024, let me tell you all something, a news flash. I refuse to be disrespected in 2024 on my job. You're not going to talk to me in a random and unprofessional and disrespectful way without consequences. I refuse. I am being paid to do a job, and I'm going to do that job with the respect of the people, the public, the lawyers, and everybody else, and I'm going to give it. You're going to stop walking around. The fact that you have children at home is your business. But we got a court hearing this morning. And if this was pre-COVID, I don't know where your children would be, but they wouldn't be interfering with this court hearing. So don't talk to me like that again. And the next time, if you have to come back for a court hearing, then you need to make accommodations for the things that's going on in your house. Because you wouldn't appreciate it if I had to keep getting up out of my chair, going to take care of some kids, a dog, the this and the that. So we're not going to do that. This is case number.
Because you would want to say that the judge was unprofessional if the judge said, hey, hold on a minute, and she was on a Zoom meeting and said, you know what? I got to take this pie out the oven. I'm going to call a slight recess while I take this pie out the oven.
And in spite of the fact that she got kicked out of court basically this morning, she's still walking around while the judge talking to her, telling her to stop walking around and still walking around. Amazing. You can't make this stuff up. You really cannot.
20450-9601, the people of the state of Michigan versus Ariel Hauser. The defendant is charged with 1 count of assault or assault and battery. And today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Ariel Hauser. Ms. Hauser, ma'am, please unmute and say your full name.
Ariel Hauser.
Today is the date set for pretrial conference. How are we proceeding?
Thank you, Your Honor. On behalf of Ms. Hauser, we would move for dismissal for the complaining witness's failure to appear.
Ms. Ritter.
Judges, at least the second scheduling of the pretrial conference, the court did require the complaining witness, Ms. Daisha Wary, to be present. I'll see the complaining witness by that name in the waiting room, and the people don't have an explanation as to why the complaining witness is not present for at least the second scheduling of the pretrial conference. At this time, Your Honor, the people will not be able to proceed based on the complaining witness's failure to appear for at least the second scheduling of the pretrial conference.
Today is the date set for pretrial conference. The complaining witness was required to appear. They have failed to appear. The people have no explanation for that failure. They are unable to proceed at this time. The court is going to grant defense counsel's motion, and the matter is dismissed without prejudice. Ms. Hauser, we will mail you a copy of the order of dismissal for your records, ma'am. Have a great day. Stay safe.
Thank you, Judge, and I apologize for earlier.
You're welcome, and I accept your apology. Thank you.
Have a great
day. Thank you, Your Honor.
Welcome.
Thanks for watching.
And also give us a thumbs up, like, comment, share. Subscribe to the channel, and you'll be notified of every video as they come up. And get that algorithm going and help us build this channel in 2024.
And make sure that you don't wind up in a what had happened situation.